Today, we're diving into a landmark UK Supreme Court case that really redrew the lines between privacy and our property rights. It all started with a simple question, but the answer was anything but. This is the story of Fearn versus the Tate Gallery. So let's get right to it. Can you actually sue someone just for looking at you? It sounds almost like a question you'd ask in a schoolyard, right? But it took 5 years and some of the UK's sharpest legal minds to finally answer it. Because in our world, looking isn't always so simple.
Picture this. London's South Bank. On one side, you have the iconic Tate Modern Art Gallery, and on the other, the residence of a super high-end, multi-million-pound apartment complex. And what started as a dispute over a panoramic view, well, it turned into this massive 5-year legal battle that challenged over a century of law.
Okay, so to really get what the court decided in the end, we first have to understand the specifics. We need to look at what kicked this whole saga off in the first place. So here are our two neighbors. On one side, you've got the residents of Neo Bankside. They're living in these beautiful, but, very exposed luxury flats with floor-to-ceiling glass walls, just 34 meters from the Tate. Then on the other side, you have the Tate Modern's new Blavatnik building, which opened back in 2016. And its main feature? A public viewing gallery on the top floor that brings in hundreds of thousands of visitors a year. You can probably see where this is going, right? That amazing 360-degree view also included a direct, unimpeded look right into people's homes.
And we're not talking about a casual glance here. Oh no. The court found that visitors were really interested in the flats. They were peering in, taking pictures, some were even using binoculars. The residents said they felt like their homes had become part of the museum's exhibition.
So you might be thinking, how on earth do you sue for that? Well, the residents' lawyers got creative. They used a very old legal tool called private nuisance. Now, this is a kind of civil wrong, a tort, that's designed to protect your right to just use and enjoy your land. Usually it's for things like a neighbor making way too much noise or a factory creating a foul smell. Applying it to someone looking at you? That was a really bold and legally risky move.
And you can bet the legal system really struggled with this. This was not an easy case, and the journey to a final decision was an absolute roller coaster. 5 years of conflicting judgments.
This is where it gets kind of wild. In 2019, the High Court sided with the Tate, and their advice was basically, buy some curtains. Then, a year later, the Court of Appeal also backed the Tate, but they went even further. They said that mere overlooking could never be a private nuisance, period. It was a job for city planners, they said, not for judges. Then, in 2023, the case got to the Supreme Court, and they just turned the whole thing on its head.
So let's get into that final Supreme Court decision. This is where they completely upended everything that came before and created a huge new precedent in English law. First, and this is absolutely huge, all 5 judges agreed on one groundbreaking point. Being watched can, in principle, legally count as a private nuisance. This completely threw out the Court of Appeal's hardline stance. For the first time, the highest court in the land confirmed that visual intrusion could actually be a legal harm to your property.
But, and this is a big but, while they all agreed on the principle, applying it to the Tate's viewing gallery was incredibly divisive. The final decision on who was actually at fault came down to a razor-thin 3-2 majority. I mean, that just shows you how finely balanced these arguments really were.
And this powerful quote from the majority's judgment really captures why they sided with the residents. Lord Leggett wrote that the constant, intense scrutiny was not normal city living. He said it was analogous to being on display in a zoo. That framing was absolutely key to their final decision.
So why the split? They all agree that being watched can be a nuisance. So why do they disagree on whether the Tate was liable? Well, it all came down to 2 fundamentally different ways of looking at the law.
This slide really breaks it down. The majority, the 3 judges, focused on a simple test, common and ordinary use. They asked, is operating a dedicated public viewing gallery a normal, ordinary use of a building? Their answer was no. It's an exceptional use. And because the Tate was doing something extraordinary, the responsibility was on them. The residents shouldn't be forced to put up curtains to fix it. But the minority of 2 judges saw it differently. They focused on reasonable give and take. They argued you have to balance the interests of both sides. In their view, the residents made themselves more vulnerable with their glass walls, and that had to be part of the equation.
So what are the wider implications here? Why does this case matter for all of us in an increasingly watched world?
The fallout from this is pretty significant. This ruling effectively ties a strong right to privacy directly to owning property. And that creates a bit of an imbalance, right? A homeowner being watched now has a stronger legal tool than a tenant or someone being watched in a hotel or a hospital. It also gives us a powerful new precedent for the digital age. Think about it. Future cases involving intrusive smart doorbells, security cameras, or even drones could now be framed as a private nuisance. Lawyers are now really encouraged to argue privacy cases through the lens of property law because this ruling has made it such a powerful claim.
And what happened in the end? Well, the Tate complied. The viewing gallery has reopened, but the section that directly overlooks the flats is now completely blocked off, bringing a practical end to this 5-year saga.
You know, this case started with this simple view, but it leaves us with this really complex and urgent question. By connecting the right to not be seen with owning land, the court has given us a powerful new tool, but it also forces us to ask, in an age where cameras are everywhere and technology sees more than ever, what parts of our lives do we truly have the right to keep unseen?